We can start with Mr. Judge. There's a hearing on Mr. Lyles.
This is the matter of State versus Lyles, 2019 5531214. Counsel, your appearance.
Your Honor, being it decided for the State, for the record, one of the victim's brothers and members of his church are in the back of the courtroom. Judge, there is another complaint on the 1214 was originally an aggravated assault, and it was upgraded. So the second complaint is 2019. Oh no, 1 second.
It's 558-1214.
558, correct. That one upgraded the charge to murder. Judge, I have a copy of the complaint if you want it.
I do not have it. I have both of the other matters where he's charged with. Wait, here it is. I do have it. I apologize. You know what? I need the updated PSA.
The PSA does not change at all.
It doesn't.
It does
The
not.
presumption would change.
The presumption.
The presumption is going to change to presumption in favor of detention. All right, so let's deal with that. All right.
Judge Jackie Poulos on behalf of Mr. Lyles. Judge, he's present in the green in the middle. He's also accompanied by his family in the courtroom today.
Okay.
We are in receipt of the complaint. We'll waive a formal reading. We enter a plea if not guilty, and we're ready to proceed on the hearing.
So, Judge, as to probable cause, I will submit on the affidavit of probable cause discovery that's been provided. Like the last case, this incident is captured on video. I would ask Your Honor to view it. While this starts as a verbal altercation involving the victim, it escalates very quickly to violence and results in this defendant and the co-defendant striking the victim, Mr. Reilly. He's first either punched or pushed to hit it, which results in him causing him to hit the ground and hit his head. Thereafter, Mr. Lyles is observed on video of what appears to be stomping on his head. Mr. Lyles was arrested shortly afterwards, did provide a statement acknowledging that he had been involved in the altercation. However, he said that in fairness, he said that he tried to kick the victim but didn't really make contact. The video, again, speaks for itself, and it's sort of, I wouldn't say it's gruesome, but it's kind of heinous and unnecessary that this verbal altercation of an individual just 2 blocks away from us here in the courthouse led to a man's death. So I would ask that Your Honor look at the video as terms of probable cause, and I'll keep my remaining arguments for detention.
Thank you, Judge. Judge, I'm not submitting on probable cause at this point. This individual is charged with murder. As we know, the statute for murder actually does require some purposeful, knowing intent. That does not exist here. As you heard from the State's recitation already, this is a case that a verbal altercation started on the street between these individuals. One individual, which is not this one, the co-defendant, is seen punching the alleged victim, who then falls into the street on the ground, hitting his head. Now, I don't have any medicals. We don't know at this point what particular injury may have actually resulted in his death. But then the next thing that happens is you do see, allegedly, my client, Mr. Lyles, run into the street, pick up his foot, and come to hit the slam on the ground. Now, you cannot see whether he connects or not. He does give a statement to the officers acknowledging his presence there, acknowledging...
Are there injuries to the head?
Judge, I don't have any
Yes,
medicals.
Judge.
Obviously, his death results from this altercation.
Okay.
But, Judge, the purpose of my argument here at this point in time is that this entire altercation between 3 people was not something planned, not something intended. They're walking down the street, they come upon this person, a verbal altercation ensues, and one person hits him 1 time, which he falls into the street, and the other person allegedly kicks him 1 time, and they leave. That's the entirety of it. And in fact, my client's wife is there, and she's trying to break this fight up. She's pushing everyone away from each other, dragging them off, saying, "Stop, guys, stop." And that's it. They do. Everybody walks away. It wasn't even, not only was it not intended, but it wasn't even known the severity of his injuries at that point in time. Now, this is charged as a murder, but even though this is probable cause, and even though the standard for probable cause is very low, and I acknowledge that, Judge, what we have here does not rise to the level of a murder. I think what should have been charged here today is aggravated manslaughter, Judge, and there's probably even a case for reckless manslaughter, but even for the charging document, it's not appropriate to the course of conduct that happened on that particular night. We don't have knowing, we don't have purpose, we don't have intent. None of those things exist. This was happenstance on the street. A fight ensued. Nobody intended for that resulting conduct, and no weapon is used. This is not, and I think there is some statutory backing, Judge, where if there's are foreseeable circumstances, again, no weapon, no repeated or multiple hits. This is not the kind of case where we're talking about where they're kicking him over and over again and there's a foreseeable action that would have resulted in his death. That does not occur here. This is not rising to the level of murder, Judge. This is an aggravated manslaughter at best.
So, Judge, again, and that's why I think it's important for you to see the video, intent can be formed in a second. Nobody is suggesting that they left the house that day intending to kill somebody. But by punching and kicking someone purposely and knowingly, if that results in serious bodily injury that results in death, that's a murder. It's not a manslaughter. There's no argument to be made that they recklessly kicked him, that they recklessly punched him. Manslaughter, whether aggravated or reckless, is based on reckless conduct. Their actions in striking the victim were purposeful and knowing. And so the portion of the murder that's specifically charged here is that they did purposely cause serious bodily injury resulting in his death. He did die as a result of trauma to the brain and to the head as a result of striking the ground. So that is the appropriate charge in this particular case because there is no reckless conduct. Their actions were completely intentional, and you will see that from the video in a moment.
So, thank you both. Let me deal with probable cause. So, I don't disagree with your statement to the extent that the intent can be formed in a matter of moments. The issue is, was the conduct perfectly knowingly and the striking, the kicking, what led up to that? I have not seen the video, but with respect to the charge, based on the proffer, what's in the affidavit, I'm satisfied the state can bear that out and has done so. It's the intentional, if you will, the personal or knowingly. Did he strike the individual with that understanding? And certainly the court can conclude, based on the standard at this point, which is some evidence, or at least a reasonable suspicion. Now, a jury can certainly come back with a lesser offense. I understand that. But there is enough there for the conduct that is alleged. If it is seen and captured on video that striking is occurring, one, to put the individual down, then continue striking thereafter. It may be one blow. Not the first time I've seen a case where one blow unfortunately results in death, and that's what we have here. So the charge, as amended, if you will, or is presented to the court, and the court satisfied the probable cause does exist. Now, 6-6, no release recommended. You want to be heard?
I think the burden shifts to myself, so I would be the first to argue for detention, Judge. Judge, despite the court's ruling on probable cause, I do think that there's an argument to be made with regards to the weight of the evidence. I'm not going to repeat myself, but I ask to take that into consideration when we talk about the weight of the evidence and where this would ultimately fall, were this to go in front of a jury or even for a plea resolution, Judge. And I do think that there's enough evidence here that this is something that could potentially and most likely resolve for a lower level offense, such as aggravated manslaughter, Judge. That being said, I did have, and I thank counsel for assisting me in being able to watch that video and seeing what's on it. And obviously, if the court's interested in seeing it, she has it available for the court. But I do want to talk a little bit about Mr. Lyles, Judge. He's accompanied today by his wife, and I know a lot of times when we talk about, well, what's going to be different if he goes back to the community? This is the same things that we have, but his wife is actually very responsible. In fact, she's there, and she's the one who's trying to make sure that this does not go poorly, this does not go badly. She's obviously a very responsible person. She's trying her best to keep things as civil as everyone can that particular day. If he were to be released, he would return to live with her at 32 Patterson Street, Brunswick. That's where they live with their 2 children. One is a newborn, Judge. He's currently working. He's employed at Joe's Crab Shack in South Plainfield. He's been there for about a year almost, and that's obviously something we don't like to take people away from their jobs, knowing that it's going to be very difficult for him to get another job. Now, I know that the court is already looking at that 6-6. Obviously, that's a concern. So I do just want to address, he's got a couple of pending files, Judge. He indicates to me that he was not even aware of that summons file, Judge. It's out of Middlesex County. Obviously, it's on a summons, which very well means that potentially he was not processed or given a court date, Judge, on that file. Could just be hanging out there. He did indicate to me that he moved. He actually did have his prior address was the Resource Center at 143 Remsen, and about a year and change ago, he moved over to the Patterson Street address. So it's very likely that there is a lot of mail issues that are going on with that he wasn't able to get those notices. But now that he knows that they're there, he's ready, willing, and able to take care of those open files, make sure that they get addressed. The rest of his record, Judge, is nothing like what you see here today in front of you. He has never been to state prison. He has 2 indictable convictions, the last one being approximately 9 years ago. His record is relatively dated, and I think that that speaks volumes about who he is this day sitting in front of this court, an individual who has now married, a new child, a job. All of these things make him the individual that he is today that can be maintained in the community, and that's what we need to decide is, are there conditions of release that would keep the community safe? And there are. He's not. He's allegedly on a level 2, Judge, but again, he's got these pending files. I don't know what the communication has been with him. I think this is the kind of case where, given sort of the set of circumstances we have, which I think we can all agree are not likely to recur, this is a very unique set of circumstances. This is not the kind of case where we deal with where somebody's repeatedly coming in on the same conduct. That's not this case. I think he could be considered to be released on level 3, even an ankle monitor if the court were so inclined to make sure we knew where he was all the time, going to work and going home, and that's it. He does live with his wife, his children, as well as their elderly parents, who he helps take care of a lot of their medical issues as well. And again, Judge's wife is here to show her support and his ties to the community.
Thank you very much. Mrs. Stein?
Judge, obviously the burden has shifted at this point, but I note that even on the aggravated assault, before we even got to the point of charging the murder, he was recommended as a 6-6, no release recommended, with the new violent criminal activity flag, even before we got to the murder. So, first of all, there's nothing that counsel has said that would shift the presumption or to overcome the presumption for detention at this point, based upon the fact that he is exposed to a life sentence and there are no combination of monetary bail or non-monetary conditions that I think would overcome that presumption. But more importantly, even without the murder charge, we would be at the same place. This defendant does have a long history, albeit I agree with counsel, it's not significant either in terms of violence or even the number of indictable convictions. However, he does have a pending indictable indictable offense in Warren County from October of 2017, which is pending at the time, as well as a DP that's pending. In addition to that, he has, if I count correctly, 2 prior indictable convictions and 5 disorderly persons convictions, as well as 6 failures to appear going back to 2006, but at least 2 of which were in 2015. In this particular case, and again, Judge, to the extent that it makes a difference for your determination on the detention, I do have the video pulled up and ready to go. Mr. Reilly, the victim in this particular case, is outside of the 7-Eleven on George Street. There is a verbal altercation which quickly and clearly gets very violent almost in a snapshot. And these individuals strike him so hard, and again, admittedly, we believe it's Mr. Robinson who first strikes him so hard that you can actually see the body hit the ground and almost come to a complete standstill. There's very minimal movement, but it looks like his arm does move when what we submit is Mr. Lyles stomping on his head. And you can see the body you can see what appears to be the left arm jerk a little bit. He is found unconscious and not breathing. Not only do they strike this man, send him to the ground, they take off running afterwards. Right? If this was some out-of-character situation that got out of hand, you would think one would say somebody's on the ground in the middle of the road on George Street in New Brunswick at 10 o'clock at night, that you might call for help. But instead, they leave the area. And part of the reason they leave the area is because and I can't remember off the top of my head, I believe it's Mr. Lyles, has a child in a stairwell in a baby carriage or baby carrier just hanging out in the stairwell, which they need to obviously go attend to. So these individuals are people, Mr. Lyles in particular shows a complete disregard for the safety of other individuals, even those around him. I do acknowledge that his wife, who is also the sister of the other suspect, does appear to initially break up the fight. It is unclear if she is stepping over the victim right after he's on the ground or kicking the victim, but That is captured on video, and she was cooperative with the police, Judge. She did indicate who the individuals were, but she does admittedly try to break it up in the beginning. Regardless, Judge, as a result of this defendant's actions and the actions of his co-defendant, we now have a man who was basically minding his own business on the side of the street until they came upon him, who is now dead. And, Judge, as a result of that, there's nothing that overcomes a presumption for detention, and I would ask that you detain him accordingly.
Thank you both. So, Mr. Lyles, there's for 90% of all the cases that we have, and the charges, there's a presumption of no detention, and that could be overcome. In your case, the presumption is the other way. There's a presumption that you stay in jail. So that has to be overcome, and your attorney really does an excellent job of trying to do that. However, I'm going to detain you, and I'm going to tell you exactly the reasons why. Despite the arguments of your attorney, I don't find that you can overcome the presumption in this case. And the reason why you have a presumption is that you're being charged with an offense where you could serve a life sentence. First-degree murder. The offense is captured on video. I've not seen the video. I don't need to see it. I accept what's argued by counsel and what's in the papers before me. So I have to look at a couple things. The strength of the state's case. It's strong. It's on video. The seriousness of the charges. You don't get any more serious than this. Your history. So I am required to look at that, and I do see that you're on level 2. You have disorderly persons offenses pending, not significant, and a third-degree shoplifting, some prior convictions. There's some failure to appears that result in the 6-6. Ms. Bowles has explained some of those. However, some of those are 2017, 2018 failure to appears, not even in itself significant. The recommendation is that you be detained. Your score is the highest that it can possibly be. I also accept that you have family here. But when I weigh all that and consider that, I believe the recommendation is accurate and believe that you cannot overcome that presumption of jail under the circumstances. Not with the strength of the state's case, the seriousness of the charges, and the fact that it's captured on video, and this all occurred while you were on level 2 monitoring. So under all those circumstances, I'm going to detain you. You have 7 days to appeal this to our appellate division. In addition, the state now has to indict you in 90 or you can be released. You do have a court date of April 29th with Judge Pincus. Counsel, thank you both.
Thank you, Judge.